Good morning, or rather, good afternoon, everybody. My name is Chris Justice, and I'm an associate with Samfiru Tumarkin. As always, I'm here today to try and answer as many of your questions as I can. So please do, if you're watching, any questions you want to know relating to employment law, whether it's maybe a question you have before joining a prospective employer, question regarding something that's going on during your actual time with the company, whatever issues there may be there, or maybe a question regarding something to do with after your employment's ended with your employer, whatever it is, get your questions in. And as I say, as always, I'll try to answer as many as possible. But as I usually do, I would like to start off the session with just a few topics up front. The first one I wanted to talk about had to do with there being more of a trend nowadays for companies to require that their employees work exclusively for the company itself and not work elsewhere. And the reason I think, or at least one of the reasons why I think that companies are starting to put in these exclusivity clauses is because there's been a change in the nature of how we do work, in the sense of us now working more from home as opposed to going into an office. Companies are, generally speaking, less able to monitor the work of their employees. They're not able to sort of determine how much time maybe that employee's spending. And so to maybe provide themselves with a little bit of a safety net, employers are, as I say, putting in these exclusivity clauses, which essentially, would be contained in someone's contract and would state something to the effect of that employee needing to either work exclusively for the company in question, or maybe as a different way it can be phrased would be to have somebody devote their full-time energy and efforts to that business. And so one question has sort of come up in regards to this new trend we're seeing, and that is, what happens if, like, say your employer asks you whether or not you're working somewhere else. What happens if your employer finds out you're working at a different location somewhere else while also doing that job? What kind of impact might there be on your employment? So with respect to the first question, in terms of an employer coming to you and asking you whether or not you have another job, whether it's part-time, full-time, or even your own business itself, self-employment, I think in part, whether or not you have to answer a question like that would depend on whether or not there is something in your contract or there's a term of your employment that speaks to working exclusively for the one company, or again, devoting full energy, efforts, and time to the one company. If that's something that's in place, if that's something that exists in your particular contract or the relationship you have with your company, then yes, you would generally be expected and obligated to answer your employer's question. And then from there, I suppose it would depend on how they respond and what effect, if any, it has on your employment. But that would answer the first question that I posed. Whether or not an employer can let you go is another question for working for another company. So generally speaking, as many of you may know, companies have the ability to terminate someone's employment for essentially almost any reason they want, as long as it's, of course, not done in bad faith. There's no discrimination at play, for instance. But besides that, they can pretty well get away with terminating people. They just need to, for the most part, provide a fair and reasonable severance package. And so that's kind of, one of the questions regarding these exclusivity clauses is that if you've got an exclusivity clause and you are working for another company and your employer finds out, can they terminate you? The answer to that is yes. But another follow-up question would be, can they terminate you and, provide you with nothing upon your exit? Can they terminate you for just cause and essentially give you no severance? And I think that's where a lot of employers will probably make a mistake, is doing that, because as many of you also may know, it's very rare for companies to essentially let somebody go with cause and not provide them with severance. So if you are somebody who, for instance, has been in a situation where you lost your job after your company found out about you working at a different place, whether or not there's a particular section in a contract that talks about exclusivity, you'll definitely want to give us a call. Because odds are you're going to be still owed severance, even in the case of a termination like that. And depending on how long you've been at the company, what your job is, etc., your severance entitlements could potentially be quite significant. Having said that, I'll get into another topic I wanted to speak about off the top, but I'm just going to hold off, given now that some of your questions are coming in. So I've got one question in from William on YouTube, who's asking, how long can your ex-employer hold your last check after leaving the job? So William, you're typically supposed to be paid all outstanding wages, vacation pay, bonuses, quite quickly after you leave a job. So if, for example, you're now in a situation where it's been weeks or months even, and your employer is still withholding monies that they rightfully owe to you, then of course that's a big issue for the employer. So if you're, William, in that situation where your ex-employer is withholding money that's owed, you'll definitely want to get a hold of us. That's something that I'm sure can help out with. You may even potentially be able to go to the Ministry of Labor and file a complaint, essentially asking for the ministry to look in and seek, repayment of all those outstanding wages. But before you contact the Ministry of Labor, before you do any of that, William, I very highly suggest you give us a shout first, just because if you do contact the ministry from the get-go, you may actually be limiting your potential entitlements. But suffice to say, there are options that you have in recovering those monies, and you may in fact even be owed more in terms of damages for the bad faith that your employer or your ex-employer looks like has sort of engaged in. But thank you for your question, William. Hopefully that answers it. I've got another question in from Caitlin, and Caitlin's asking or saying that she works for a landscaping company and they renew her contract every year on an annual basis. This most recent year, they told Caitlin that they're ending her contract early and won't likely renew it in the spring. And so Caitlin's asking whether or not she's owed any severance, or if she's out of luck due to the sort of seasonal contract nature of her role. And so this is a good question. This question has to do, of course, with employees who do renew a contract year after year. So in a lot of situations, you'll typically sign one contract at the beginning of your job, and you may not even sign another one unless you get a promotion of some sort or there's a big change to the terms of your employment. But there are also individuals who, as Caitlin has done, will sign a contract basically every year, just renewing it for that year. But for all intents and purposes, nothing else changes. So it's not really doing anything other than setting out a specific time frame. And a lot of times when employees are in the situation where they're having to sign contracts every year and they get let go, oftentimes they'll only be given severance as though they worked for a year, meaning the most recent contract they signed. And actually no credit is given whatsoever towards, all the other years that they put in, all those other contracts that they signed. And that's a mistake on employers' part. If you're an employee and you've signed 10 contracts, each for a year, and you've been there for 10 years and you're let go, odds are you're going to be looked at as a 10-year employee, and you're going to be entitled to severance that would befit a 10-year employee, and not something that would be more likely to be given to a 1-year employee. So not only that, but yes, Caitlin's asking, first of all, whether she's even owed any severance whatsoever. And whether it's a year of severance, a month of severance, whatever it is, there's of course a very high likelihood that she is owed it. And as I say, something likely to take into consideration all those years she's worked. Now, oftentimes, in many cases, it will also come down to the contract itself. It's important to understand that if you're somebody who has a contract and you've signed it, there may be a chance that there's some words or some language in that contract that could limit things. So to be fair to Caitlin, there would have to be a review of the contracts that she signed, especially the most recent one. But in my experience, the vast majority of these situations tend to play out where the employee does in fact get their full severance for all the years they've worked. But thank you for your question, Caitlin. I think it's an important one because a lot of us now find ourselves in those situations where we're signing contracts year after year. And as I say, sometimes employers mistakenly think that they can sort of benefit the most at the end of a relationship like that one. I've got another question in from Carrie Smith on YouTube, who's asking, what if you have a hobby type of business? Would that fall under exclusivity? And Carrie's mentioning that they do custom woodwork jobs in their spare time, but it's not really a full salary. So Carrie, in terms of a hobby, a hobby type business, it's a bit of a contradiction there. I would say if you are engaging in some activity or providing some service that generates income, and I think this would qualify under that, then it could constitute, of course, self-employment. And depending on how much time you put into that hobby, it may or may not be an issue, practically speaking. But I would probably err on the side of saying, yes, that is technically a business, even if it's something you enjoy as a hobby as well. So I would at least treat it that way for purposes of whether or not, it would constitute alternate work and whether or not it would potentially put you in a certain situation regarding this whole exclusivity business. So Carrie, hopefully that answers your question. I mean, of course, if you are, again, in a situation where your employer is coming to you saying, we want to make sure you're working only for us, are you doing this? Are you doing that? Give us a call before, I think, communicating anything, because it may depend on specifically what you're asked. And it may also depend on what your contract says. It's one thing to have a contract that talks about working exclusively for the company. But it also depends on how it's specifically worded, because that could give you a possible out as well. Not to mention, there may be some discussions with your employer about this. And so you'll want to kind of have an idea of what best to say and how to kind of address that situation with your employer, because it's also possible that your employer may not mind as much. Your employer may, despite there being an exclusivity clause, allow you to continue doing what you're doing, especially if it's something that's not maybe comparable in terms of the amount of time you spend on it. Maybe it's something you do during the weekends, for example, and it has no bearing whatsoever on your Monday to Friday job. So there may be still a way out and a way to kind of communicate and discuss that or bring that up with your employer in any case. But thank you for your question. I've got another one in from Antonio on YouTube. Antonio is asking whether or not you can, or whether or not your employer can force you to return to work. There's been a threat made that Antonio will be terminated if he doesn't return to work. He's driving a truck within 4 weeks after knee replacement surgery and stopping benefits. So again, this goes back to the terms of your employment, Antonio. I think if an employer is asking an employee to return to the workforce, like in terms of the specific physical location, let's say that employee is working remotely, but the employer wants them to go back into the office. If there's no term of employment that says you can work from home remotely for an indefinite period of time, then in a lot of those cases, employers will be able to recall somebody back to the office, even if you can do your job remotely from home, and even if it may not make the most sense. If the last contract you signed says you're to go into the office Monday to Friday, again, even if you've been working remotely for the last 2 years, your employer may very well have the right to, in a sense, force you to go back to work. And if you don't, you might be deemed to have quit your job, which then is gonna create a whole host of other issues. So if you're anyone who's being asked to go back into the workplace, the physical workplace, before you immediately reject that or get into any prolonged discussion with your employer, you want to get in touch with us so that, again, we can kind of walk you through how to best communicate and have a discussion about that issue. So that's kind of more generally. Now, Antonio, in your particular case, you've mentioned as well, not just that your employer is forcing you to go back to work, but that you've had knee replacement surgery. So your employer may very well know that you've had this surgery, and you may require some time off as a result of the surgery in order to recover. And if your employer is aware of this and they're still putting pressure on you to go back into work, then that can create a whole host of other issues for the employer. So typically employers are required to accommodate your circumstances, especially if you've got an injury, a physical limitation that would constitute a disability that's in need of accommodation. And if it's depending on the length of accommodation needed, I mean, you could technically take time off work for months or years if you needed to in order to recover. So generally speaking, an employer can't also force you to go back to work in the face of being presented with evidence that you need time off. So you should be asking for an accommodation if you can't go to work, but you can still work remotely, for example. And if you can't work remotely either, then you may be able to use potential sick benefits, disability benefits. So there may be other options there. But yeah, your employer really runs the risk of being exposed to some bad faith by forcing you to go back to work and threatening to terminate you. I mean, there's potential human rights concerns. There's obviously your typical severance issues in terms of how much you're owed. So it seems like in Todio's case, there's a lot going on. But there's a lot of things that the employer seems to be doing incorrectly. So I think this is, again, one of those situations where you want to be extra careful in terms of what you communicate to your employer, making sure that they're aware of all the information, making sure that maybe they've got medical notes from your doctors, sort of supporting the time off that you need. And at that point, you'll have pretty much done what you can do. And if they want to take that action of termination, then your potential rights, as I say, are quite significant. But definitely give us a call, Antonio. It seems like there's a lot going on there. And again, you just want to make sure that you're not saying or doing anything that could affect the case down the road. But thanks again for your question. I've got another one in from Connor on Facebook. Connor is saying that his employer has just told him that he's going to be put on a performance improvement plan. And he's asking, what exactly does this mean? Should I be worried about losing my job? So many of you might know of the idea or the concept of performance improvement plans, or PIPs. A lot of times companies will sort of place somebody on a performance improvement plan where in a situation where the company believes their performance in some way is subpar. And they're expected, if this is going to happen, to clearly identify the ways in which the performance is subpar. Companies, of course, need to justify putting somebody on a performance improvement plan to begin with. They cannot simply, obviously make up anything. They can't, sort of give or provide certain critiques of someone's performance if it's not fair, and use that as justification to put somebody on a PIP. So even the fact of being placed on a performance improvement plan, if it's not warranted, could justify what's called a constructive dismissal, and could result in the employee actually being able to treat that as a termination and get severance. So that's why, again, companies need to be extra careful about who they put on a performance improvement plan, and sort of the reasons why. Because, as I say, that could trigger termination rights right there. If you're put on a performance improvement plan, and you do have issues with the criticisms that are being presented against you, and you're an employee, you'll also want to make sure that you push back. You want to voice your objection. You don't want there to be on record a document from the company that says you are performing poorly without any response from you. Because if time goes on, then you could be very well seen as having accepted or agreed to those criticisms. And then it's going to be harder for you later on to kind of fight that battle. So you definitely want to have a discussion with your employer, get a full understanding of why you're being placed on the plan. And if you have objections or concerns about why, or some disagreement as far as the basis for being put on the plan, you want to record those objections. You want to put that in writing. You want to let your employer know. And then your employer, for all you know, may sort of withdraw some of the criticisms. They may take away the performance improvement plan, or they may double down and just say that what you're saying is wrong and what they're saying is right. And then you might be in a situation where there's this dispute that's going on, but at least you have noted your objection in writing, so that later on, if there does come a point in time where you lose your job and the company tries to rely on, the criticisms that it had, the performance improvement plan and all that, again, you have on record your objection, and they will, the company that is, will be less likely able to rely on that as a way to get rid of you. Because when somebody is put on a performance improvement plan, there is, of course, always the potential that a termination may happen shortly down the road. Now, that may be months, that could be weeks. Typically, it's months, because anytime someone's put on a plan like this, companies are expected to give that individual time to improve. So you can't, for example, put somebody on a performance improvement plan on a Monday, and then by Friday say that they didn't perform as well and that they're being let go with cause. So there's got to be some time given to improve your performance, and there has to be continued failure to improve your performance before a company can sort of build a case to let you go for cause. As I mentioned at the beginning of today's session, it's very rare that an employer will have cause to terminate someone's employment, because if they do, that means you get nothing on your way out. And even in cases where there are performance issues or allegations of poor performance, and even if those allegations have spanned a number of months, there's still a good chance that if you get let go, you're going to be owed severance. The company's not going to have just cause. The company really has to do a lot to establish just cause based on performance. They've got to make sure that all their criticisms are legitimate. They've got to make sure that they've given the employee, as I say, an adequate chance to improve. There needs to be multiple warnings given. There's got to be consequences laid out very clearly in those warnings, or in those meetings, whatever is held with the company, as far as what could happen to your employment. And there also generally needs to be some assistance given by the company in terms of helping the employee perform to those expectations. And last but not least, there also has to be realistic standards. So it's going to be much less likely that a company is going to be able to justify terminating someone's employment for cause if the standards are unrealistic to begin with. A company may not be happy with your performance, but their goals themselves are just going to be way too lofty. Then that's another situation where it's going to be a lot harder for them to establish that there's cause in that case to terminate your employment rather. So, just going back to Connor's question, again, this is another situation that I'd recommend you get in touch with us on, because it may be something that you're going to be dealing with potentially for a number of months down the road, as far as being on this plan, as far as having maybe one-on-one meetings with your employer about certain progress being made or not being made. And again, you want to just make sure that you communicate that in the best way possible, so that you're papering your trail. And then later on, if you do lose your job, at the very least, you've got kind of all the evidence needed to support your case, and potentially go after the employer, not just for severance, but also for those bad faith additional damages. To the extent there's any bad faith in terms of the plan itself, the legitimacy of the plan, of course, that can expose them to bad faith damages. And a lot of times companies, as a way to absolve themselves from having to pay any severance, will sort of unfortunately create instances or situations where they're trying to get rid of people and not having to pay that. And being put on this performance improvement plan in many cases is that situation. So hopefully that answers your question, Connor. Again, appreciate it. I know it's something that a lot of people nowadays, and just for as long as I've been working, have had to deal with. I did want to just get back to an upfront topic that I mentioned earlier, but I've just got another question in from Hazel. Hazel on YouTube is asking, what does it mean if my employer sent me salary continuance forms and said I couldn't return to work until the forms are completed by a doctor? So I think I might need a bit more information, Hazel. So your employer's sending salary continuance forms, I presume, for you to fill out in order for you to get paid salary continuance. It sounds like to me you might have been terminated from your job, because that's normally the only situation where someone's owed salary continuance. But you're also mentioning not being able to return to work until forms are completed by a doctor. So it could also be, Hazel, that you are maybe looking to receive benefits, wage loss benefits, like replacement benefits, due to an injury. So if I'm correct, then it seems like, yes, you do have to fill out forms completed by a doctor if you cannot return to work to establish your absence. If you're someone who can't work for XYZ reason, then you're typically going to have to provide some information to your employer through your doctor to verify that. And that doesn't mean you have to give your employer a diagnosis. It doesn't mean you have to give your employer any information regarding any medications that you need. But it does mean that you have to give your employer an idea of what your limitations or restrictions are, and how that prevents you from being able to do your job. And if possible as well, a general idea of how long those restrictions are going to last. And as I say, it seems like your employer is just asking for that information to be provided to them by your doctor. And then after that point in time, it seems like, again, you're going to be receiving some form of salary continuance or wage replacement. Now, I wouldn't sign any forms or anything before talking with a lawyer. And just because I want to make sure that I'm answering the right question too, I would hold off from doing that. And I suggest, if anything, you give us a shout just to confirm that I have my understanding correct about your situation. But it seems like that's kind of what you're getting at. I've got another question in from Rocket on YouTube, who's asking, how is it that employers can contract out of common law severance for the minimums under the ESA if the maximum is what you are owed at law and not the minimum? So it's a good question, Rocket. At the very least, as you seem to know in your question, employers, when someone is terminated, have to provide somebody with a certain bare minimum entitlement. If you're a provincially regulated employee in Ontario, that's going to be the Employment Standards Act, the ESA, which is what you've mentioned. If you're a federally regulated employee, that's going to be the Canada Labour Code, the CLC. And these legislations set out what the bare minimum severance is for a particular employee, depending on how many years they've worked there. So in no case, if you're let go without cause, will you as an employee receive less than that bare minimum. But if you have a contract that says you're only owed the bare minimum, and assuming it's enforceable, because a lot of contracts do try and limit someone's entitlements, and everyone needs to know that if you have a contract that is saying you're only going to get the bare minimum, do not assume that it will have that effect. Don't assume that the contract is actually enforceable. But in the odd circumstance where the contract is enforceable and does effectively remove the potential for you to get more than just those bare minimums, then that is okay as far as Ontario law is concerned. The common law, the way that you maybe can view the common law, is as a potential maximum. It's not necessarily a guaranteed maximum. It's not something that you're owed. There's not a specific common law amount of severance that anyone's owed per se. It will depend on a variety of factors, like how old you are, how long you've been at the company, what your position was, what other jobs are out there that are like the position that you had. So when we're talking about common law severance, number one, it's not a guarantee. And number two, there's usually a range. So for example, in one situation, 12 to 16 months of common law notice or severance might be sort of warranted or fair. But if you've got this contract, as I mentioned, that limits you to just the ESA minimums, just the legislative minimums, then yes, it is possible to do that. It's just very rare for a contract to be worded in that way. But you shouldn't view common law necessarily as something you're being owed in any case. It will depend on the case. It'll depend on the contract, if there is one. It'll depend on how long it takes you to find a job and whether you've settled your case by then as well. So long and short of it, though, employers can contract out of common law. It just takes very specific language in a contract to do that. And that's, relatively speaking, very rare in my experience. Having said that, I realize I've reached my time for the day, so I'm going to let everyone go on that note. I thank you again for all your questions. I will say that we've got another live stream going on, as you just see there below, 1 o'clock Pacific, 4 p.m. Eastern. That's October 4th with Darren Saul. He's one of our associates based out of Vancouver. So definitely tune in if you've got any questions, and I'm sure he'll be happy, as I do, to answer as many possible. And I will see everyone again soon enough. But thanks again for attending, and have a great rest of your day. Thanks. Bye for now.